case to come before the court is State versus Scofield. Both sides ready to proceed?
Yes, Your Honor.
You each will have 15 minutes to present your arguments, and the appellant may reserve up to 5. Just let me know what you'd like to do. Thank you.
May it please the court. Allison Hibbert, and I represent appellant David Scofield. I'd like to reserve 5 minutes for rebuttal.
Thank you.
This case is about two main issues. The first being the forfeiture issue, the property that was found in the appellant's car that was ordered to be confiscated or destroyed at the sentencing as an aspect of his punishment, and then the other issue being the GPS monitoring for 18 months as an aspect of his probation. So at defendant's sentencing, the property that was found in his car was ordered to be confiscated or destroyed. That included some law enforcement related property, such as a hat, a radio, an antenna, and then it also involved firearms that he legally owned. The forfeiture statutes in Ohio are very clear as to what they require when property is going to be forfeited. And in a misdemeanor case, the statutes require that the charging document, so in this instance the complaint, have the forfeiture specifications that describe various aspects of the property that have to be included in that specification. The complaints in this case did not have any forfeiture specifications in them. So, the order that the property be confiscated or destroyed was in direct contravention of those forfeiture statutes. Forfeiture is not favored in Ohio, and whenever possible, the statutes must be construed so as to avoid that forfeiture. So, I think that issue is fairly straightforward. The forfeiture statute.
The question is, the city says that, or the state says that we needn't even reach that issue because your client is a fugitive from justice.
That's correct, he is. He is a fugitive from justice. A warrant was issued, and he has not turned himself in. However, there is the fugitive disentitlement doctrine, which has been used to dismiss direct appeals. But the United States Supreme Court has cautioned that that doctrine should not be used when there's no connection between the fugitive status and the issue in the appeal. And as to the forfeiture, there is no relation between the fugitive status, between Mr. Scofield's fugitive status and the forfeiture issue. The forfeiture issue arose in the sentencing and has not been affected at all by his fugitive status. So that forfeiture was ordered, and subsequently to that.
I get what you're saying, but it almost, and obviously I see the better connection between the fact that he's also complaining about the GPS and so forth. That directly relates,
Right.
perhaps, to the fugitive status. But also, if he's not around to claim any of this property, it's almost akin to a standing type issue as well.
Well, I would say that he can claim that property. He just subjects himself to entering the jurisdiction and being arrested on that bench warrant. But he's still entitled to the property. And there's a Supreme Court case, Deegan versus United States, in which there was both a criminal action and a civil action. The criminal action, the petitioner was indicted for distributing marijuana, laundering money, and related crimes. And the government similarly filed a civil forfeiture complaint. And in that case, the petitioner moved to Switzerland. He was a dual citizen. He moved to Switzerland, and the Supreme Court held that that fugitive could not be disentitled, and that he could defend that civil forfeiture action. And in this case, while the forfeiture was an aspect of Mr. Scofield's punishment at his sentencing, it's very similar. The forfeiture issue is almost a civil issue in that it was, he has the right to due process to protect his property. And so, I think that this is very similar to that case in that he should be allowed to pursue this issue in his appeal for his property despite the fact that he has the bench warrant resulting from a different aspect of his sentence. And I guess also with regard to the forfeiture issue, the state cited the Klein case in their brief, and in that case, they did not even reach the merits of the forfeiture. Because the defendant in that case had not challenged that in his direct appeal, and he had waited and filed a replevin action, and that was the case, his replevin action was the case that they were hearing. So they didn't even reach the merits of the forfeiture issue in that case. And they said that any problems relating to the forfeiture should have been brought up on his direct appeal. And that's what Mr. Scofield did in this case. And the other case that the state cited was the Vanderapalli case. And in that case, the court did hold that the vehicle was an instrumentality and it could be forfeited. But in that case, the indictment had the forfeiture specification. So the argument is not that instrumentalities can never be forfeited, it's that the proper procedures must be followed, the procedure that the statute very clearly outlines. With regard to the GPS issue, Mr. Scofield was ordered to wear the GPS device for the sole purpose of tracking his movements while he was on probation for 18 months. His movements 24/7, nonstop. There was no location limitation. It was just so that the judge would know where he was at all times. And that it's overly broad, and it's very invasive to have your movements tracked 24/7 for 18 months straight. In the Beringer case that the state cited, the court wanted to monitor the defendant's actions in a specific neighborhood. In this case, Mr. Scofield was able to go wherever he wanted, but the judge just wanted to know where he was at all times. And it can be analogized to a search of him, of his person, of his movements.
Does the case law require us on review to consider all of the circumstances? Isn't it a totality of the circumstances on a case-by-case basis?
Right, right.
And in this case, we have an individual who was convicted of impersonating a police officer, had weapons, and was apparently licensed to carry them. But the circumstances of the arrest even would give rise to very strong concerns on the part of the court as to what could happen if he were permitted to go on about his business. I mean, from reading the briefs, it sounds as if he had a what do you call those lights? Not a strobe light.
A spotlight.
Yeah, a spotlight, sort of a take-down light, and was shining it in the window of an off-duty police officer. That could have been a citizen who, given the kind of car he was driving, the markings on the car, he had weapons and a uniform. One doesn't have to go very far to imagine what could have happened. And so under those circumstances, how do you argue that the trial court abused its discretion in ordering a sentence that monitored his whereabouts under those circumstances?
Well, he was still able to go. There were no limitations on that, so he was still able to go wherever he wanted. But really what it was a tool to gather evidence of any future crimes of his. And there's no reason to believe that he would do that in the future.
Well,
aside from his past,
and aside from the fact that he's a fugitive.
But the government could use the resources that they have to gather evidence of any crimes in the future, as opposed to conducting 24/7 tracking of everywhere he goes.
Well, couldn't it be more of a deterrent too? If you have GPS device on for 18 months, you're less likely to do anything, right?
Yes, but I mean, he could still go to all the same places. So, it wouldn't prevent him from,
Committing a crime?
I mean, he could still just as easily, do everything that he would do. There's just a tracker on him. But I mean, it's excessive to be tracked 24/7 and have somebody know your every movement for 18 months straight, every place you visit.
It's not as excessive as imprisoning or incarcerating somebody.
This is true.
178 days suspended.
You're in your 5
Yes,
minutes.
thank you.
Thank you. Good morning.
Good morning, Your Honor.
You may proceed.
Yes, Your Honor. May it please the court, my name is Tom Bound. I represent the city of Akron, state of Ohio, in this appeal as the appellee. Your Honor, as I see it, there are 3 issues before this court: the fugitive disentitlement doctrine, the issue of the forfeiture of the personal property, and the GPS as a search. First, I want to address some of the things that appellate attorney brought up. One of the things that, in examining the statute very closely, I believe it discusses this is a method, this is one method. I don't believe it ever says this is the sole, exhaustive, only way to do this forfeiture aspect. It says if you're going to address the forfeiture, it must be done this way, but there are other ways where it can be done. Going back to the fugitive disentitlement doctrine, appellant cited Deegan v. United States for the proposition that you could still defend the civil aspect of a forfeiture. That is correct, because the only penalty, the only remedy in a civil case is property being ordered in terms of monetary value or some sort of restriction on that property. This is a civil case, this is a criminal matter in which the issue is one of liberty. So I believe there is more at stake in this situation, so a defendant would have more motivation to come to court to participate, versus if the only remedy from a court is a civil matter, there is less of a concern in my mind as to that.
But the law is clear that forfeiture is a civil remedy. It's an in rem proceeding. So even though it comes about as a result of a criminal action, the forfeiture aspect is against the property, not the individual.
Correct, Your Honor. But I would say before you even get to that, the court steps back and says, well, as to this criminal appeal period, the fugitive disentitlement doctrine, before the court need even get to the issue of the forfeiture and the GPS aspect, I believe, because it's a criminal matter, there's liberty at stake, and the defendant has, Mr. Scofield has more motivation to participate because his liberty is on the line. I would concede that as to the Klein case cited, it was a different procedural matter. It was an issue of res judicata, so they didn't get to the merits. As to the GPS issue...
Counsel, before you leave that area,
Sir. Sure, Your Honor.
It's very difficult to read the court's order here that's attached. It says firearms confiscated, and I don't know, did you say in your brief, I don't know that you addressed this, the order confiscating destroyed, I assume they have not been destroyed yet?
That's my understanding, Your Honor, in part because I've heard from the property office of Akron, what are we doing on this case? Well, there's pending appeal.
That's not really in the record, though, right?
As to the confiscation, whether it's happened yet, I don't believe it's in the record.
I mean, the destruction, yeah.
It hasn't happened yet. I know that for certain, Your
All
Honor.
right, just wanted to make sure about that.
Correct.
Thank you.
No problem, Your Honor. As to the GPS matter that appellate counsel brought up, she cites the Bay Village versus Behringer. There are limitations there. You're restricting someone's freedom. You're telling them that they cannot go somewhere. That's a reasonable restriction on probation. As to the ability of somebody on probation to have evidence used against them, there are less rights given there's less of a standard of proof required when someone is on probation. So a probation officer can check in on a probationer, see what their living situation is, and there's less of a standard of proof that's required to potentially search and gather evidence. So I don't believe that the GPS restriction is improper in any means in this situation. It is beyond dispute that there was a vehicle involved. This is very specific as to it happened on an interstate freeway. So I think it's absolutely appropriate. Mr. Scofield does not live in the local jurisdiction. He lives outside of the jurisdiction, I believe approximately 2 hours south of the Akron Municipal Court's jurisdiction. So I do believe that is a reasonable restriction as to the matter. Reasonable restriction on Mr. Scofield, I believe. Turning back to the fugitive disentitlement doctrine, I believe it is absolutely an issue of authority of this court. If Mr. Scofield does not want to participate, he is essentially thumbing his nose at the government. This court system is a co-equal branch of the government. He should be respecting the process. And as of this morning at 9:30 this morning, I can tell this court is an officer of the court. Pursuant to the online records of the Akron Municipal Court, there is still that pending warrant for Mr. Scofield's arrest. As to the fugitive disentitlement doctrine broadly, I present this court with a couple hypotheticals, certain situations. Now, I realize this is a misdemeanor case, but I think this applies broadly to what if somebody were to be sentenced on a rape conviction. For whatever reason, the court says you have 2 weeks to report. What if that person does not report? There is a sentence that has been given, and so for all intents and purposes, it's a final appealable order, but that person who was convicted with rape, he's not in the court's jurisdiction because he's out and about, has not reported to prison. What if somebody charged with murder is sentenced, and after the final appealable order is done, there's a notice of appeal filed, the appeal process is started? What if he escapes from prison? He's not participating in the system. So I believe the fugitive disentitlement doctrine should apply in this situation, and the court should not even get to the other merits of this. As to the Banda Rapalli, I'm not so sure in that case if it does reference that the indictment contained specifications. I think the bigger issue is the instrumentality argument. That case does cite a case out of this court, I believe, a case out of this court, the 9th District, Gelenti, in which the 9th District agreed with the trial court's decision that the instrumentality aspect did not apply. So I would ask this court to follow the Banda Rapalli case because it does fit the instrumentality. The guns used, the other items used, the other personal property that was used does fit the instrumentality of the crimes of impersonating a police officer and the firearm aspect of the crime he was charged with. Again, as to the GPS aspect, specifically, appellant counsel does cite, I believe it's Grady versus North Carolina, which was recently cited by the U.S. Supreme Court. That is a wholly different case. That is a completely different aspect. That is a case in which somebody post-criminal case, post-sentencing is being determined whether we can put GPS on him when he has no criminal case any longer. That is not at all the situation we're in. I asked this court to, if it gets to that merit of the GPS, find that a GPS monitoring is a wholly appropriate restriction. It is clearly less invasive than somebody being required to be on a scram bracelet in which alcohol can be detected. That is so specific as to you're not allowed to drink wine, drink beer, something like that. That is far more invasive, and the courts have said that is perfectly appropriate. If this court has no more questions.
I don't believe so, thank you.
Thank you. I would ask that this court overrule the appeal. Thank you.
Thank you. You have about 4.5 minutes.
Okay, so the appellee discussed that the forfeiture statutes were not the exclusive way to have property forfeited, and Ohio Revised Code 2981.04 does specifically state that the property may be forfeited only if the complaint contains the specifications. So it would, a direct reading of the statute would seem to indicate that that is in fact the only manner in which instrumentalities may be forfeited in a misdemeanor case. The Vanderpolly case.
Counsel, I know you said it wasn't part of like the plea.
Correct.
But let's see here. There was a PSI, but then the defendant obviously was brought in for sentencing. And the court has it marked down as part of the sentencing. Do you know, do we have the sentencing transcript in front of us? Let me ask you that first.
I believe
In the record, I mean.
in the record, yes, it should be, yes.
Okay, I'm just wondering what the court actually said to the defendant as she was sentencing him about the confiscation and destruction of the firearm and the hat and all the other evidence that's taken.
I would have to check. I don't know the.
That's fine. I just want to see if it is in front of us. Now, I've taken the position you don't always necessarily have to object in certain circumstances at sentencing, but the court as a whole has not necessarily agreed with me all the time. So what if she says, and I hereby order the destruction, blah, blah, blah? What do you say to that?
I would say that the forfeiture statutes were not followed because
And if he didn't object?
if he did not object at that time, well, I think then there would be a problem of raising it after the fact as an issue. But aside from that, I don't know that that would be proper for a judge to just order property destroyed or confiscated. It seems like there would be a lack of due process there.
I didn't mean to throw all that on you, and I apologize
No,
about
no,
that, but it
it's
just
fine.
entered my mind as
Yeah.
I was looking at things, and I remembered my days in Muni Court and how we handled things, so I was
Yeah.
just wondering about that.
I mean, I just think that the statute itself is very clear that the property can be forfeited only if the complaint contains the specifications.
Thank you.
As to the GPS issue, I think I would wonder if you could order someone in Mr. Scofield's position to wear a GPS tracking device 24/7 for 18 months. How many other offenders could you put on a GPS tracking device? Like, where do you draw the line then? So many people, use their car to commit crimes, whether it be to go pick up drugs or to, go take a prostitute to meet someone. I just think that if a GPS device can be used in a case like this for a nonviolent misdemeanor offender, it could be used all the time for anybody. And it's so invasive, and there doesn't seem to be anything about this case that warrants that. And it would open the door to allowing this to be ordered in, simple cases, cases of, theft cases, somebody who steals, but even then, even in a theft case, somebody who steals rocks from parks, even then, there's parks involved, so it's to see that they don't go to parks. But, in this case, there's just no location limitation, and so it seems excessive and overly broad. As far as the Vanderpolly case with the instrumentality being forfeited, forfeiture specs were charged in that indictment. Unfortunately, I do not have a copy of the indictment, but I would ask the court to take judicial notice pursuant to Evidence Rule 201B and D that the indictment did contain the forfeiture specifications. I was able to pull up the journal entries on the docket yesterday, which mentioned the forfeiture specifications in the indictment, but was not able to get a copy of the indictment.
And counsel, you're out of time.
Okay, thank you.
Thank you for your presentation to the court. Thank you for both sides. The court will take the matter under advisement and will issue a written opinion that will be sent to both of you, as well as it will be posted on our website. Thank you so much.
Thank you, Your Honor.